in the courtroom.
All right. This isn't a purely circumstantial case. And so I'm going to deny the motion for JOA.
It looks like the case is closed, but Judge Schott has other business with Gonzalez.
Ever wonder what happens when the very people upholding the law break it? Or when a judge has simply had enough? Today, we're diving into 3 insane courtroom dramas that push the boundaries of legal procedure, professional conduct, and sheer disbelief.
Now, we have this other case for driving while license suspended.
2 months after her DUI arrest, Gonzalez was ticketed for driving with a suspended license. Problem is, the only reason her license was suspended was because of the inaccurate paperwork filed by Officer Wagner.
First, we witness a Florida judge's explosive reaction when he discovers a police officer's mistake had profound consequences for a defendant, leading to an extraordinary reversal. Then we head to California, where a deputy attorney general completely loses her cool during a civil trial recess, resulting in a physical altercation with a bailiff and a shocking arrest. Finally, we analyze the dramatic plea hearing of a former Kentucky sheriff, whose last-minute change of heart lands him right back in jail. These aren't just viral clips, they're critical lessons in legal ethics, judicial power, and the high stakes of courtroom conduct.
I want to be enlightened.
It was a mistake, admittedly, by Michael Wagner.
I know.
He testified to that today.
He caused her to have her driver's license suspended for at least a few months for nothing. So are you going to null process that case? Or am I going to get mad at you today?
Here, Judge Schott is visibly frustrated, and for good reason. The defendant, Lizette Gonzalez, had her driver's license suspended due to what Officer Wagner admitted was a mistake on the paperwork. In Florida, driving with a suspended license can lead to serious penalties, ranging from a second-degree misdemeanor with up to 60 days in jail for a first offense to a felony for a third or subsequent conviction. If the defendant knowingly drove with a suspended license, the judge is essentially asking the prosecutor, Diana Mears, if she intends to null process, short for null prosequi, which means to voluntarily abandon or dismiss a criminal prosecution. He's hinting that the underlying basis for the suspended license change is fundamentally flawed due to the officer's error, which could indicate a lack of the knowledge element required for conviction under Florida Statute 322.34.
A sworn
Absolutely
citation.
not, Your Honor, and that is not true.
I'm dismissing. I'm dismissing. I am dismissing this charge. No, I'm dismissing the charge.
This exchange is explosive. The prosecutor tries to downplay the officer's actions as a mistake, but Judge Schott emphasizes the severity. He lied on a sworn citation. A sworn citation is a formal legal document, and making false statements on it can constitute perjury or official misconduct, even if the officer later claims it was an error. The judge's outrage stems from the potential abuse of power and the impact on the defendant's rights. Falsifying official documents undermines the integrity of the entire justice system. His swift dismissal of the suspended license charge demonstrates the court's power to intervene when due process is compromised by police misconduct, regardless of prosecutorial intent. He's exercising judicial authority to ensure justice, especially when there's an undisputed factual error directly impacting a new charge.
Granting, I'm rescinding the sentence. I'm granting the JOA.
Judge Schott has just reversed his decision and acquitted the defendant on the spot.
So you're granting it because you don't agree with the state's decision on
I'm
the
granting
other
the
charge?
JOA in fairness.
In fairness, because you don't like the state's decision today, Your Honor, on the case?
No, you're not. Now that I consider what Officer Wagner testified to and how many times he basically tripped over himself just to arrest this lady with no real probable cause. You're done. Motion to JOA is granted.
And you're not going to provide a written order on that?
Nope. You want to appeal me? Appeal me.
This is an extraordinary moment. The judge has just reversed his initial decision to deny the motion for judgment notwithstanding the verdict, or JOA, and is now granting it, effectively acquitting Lizette Gonzalez of the DUI on the spot. A JOA, or in some jurisdictions a directed verdict, is a legal maneuver where a judge sets aside a jury's verdict, because as a matter of law, the evidence presented was insufficient to support the verdict. Here, Judge Schott explicitly states his reasoning. Officer Wagner's testimony lacked credibility, and there was no real probable cause for the arrest. Probable cause, as protected by the Fourth Amendment of the U.S. Constitution, requires sufficient facts and circumstances to warrant a prudent person in believing that the suspect has committed, is committing, or is about to commit an offense. If the officer's testimony was so weak and contradictory, it could indeed negate the probable cause necessary for a lawful arrest, making any subsequent conviction legally unsustainable. The judge's defiant "appeal me" signals his firm conviction in his ruling, and his perceived need to correct a grave injustice.
Next, we're in San Luis Obispo, California, where even though court is in recess, things are heating up between opposing counsel. On one side is Timothy McGill, whose client, a state hospital employee, is suing for wrongful termination. And on the other end of the table is the state's second highest ranking legal officer, Deputy Attorney General Jenny Mariah Kelly. Moments earlier, during cross-examination of a state witness, McGill asked the witness if she had met Kelly earlier in the day, prior to testimony. This particular question, an effort to potentially cast doubt on the witness's credibility, angers Kelly. And now she's letting everyone know. Gesturing wildly and reportedly raising her voice, bailiff Tyler Brooks approaches Kelly and tells her to stop shouting and then asks her to leave the courtroom. But based on Kelly's body language, it appears she's not interested in going anywhere. And now here's something you don't see every day. A state's Deputy Attorney General about to be escorted out of court. If only it ended there.
This dramatic scene highlights the crucial importance of courtroom decorum and the rules of professional conduct that all attorneys must adhere to. Even during a recess, attorneys are expected to maintain professionalism. The bailiff, as a peace officer, has the authority to maintain order in the courtroom, and refusing to comply with a direct order to lower one's voice or leave can escalate quickly. For an attorney, especially a deputy attorney general, such behavior could lead to sanctions from the state bar, not just criminal charges. The charges of resisting a peace officer under California Penal Code Section 148A and disturbing the peace under California Penal Code Section 415 are serious, especially for a legal professional, as they directly challenge the authority and order of the court.
According to the sheriff's report, after Kelly refuses to lower her voice or leave the courtroom, the bailiff then grabs her hands to escort her out. But when she pulls away, the bailiff wrestles her to the floor. As Kelly's co-counsel looks on in disbelief, other deputies arrive and help handcuff Kelly as she continues to resist. Once on her feet, a few more words are exchanged before she's finally escorted out of the courtroom. The California Deputy Attorney General was charged with resisting a peace officer, but later pled no contest to the lesser charge of disturbing the peace. She was also ordered to pay a $1,000 fine and complete anger management classes. Next, we go to a hearing in Breckinridge County, Kentucky, where the defendant is not typically the one standing before the judge. The accused is Todd Pate, the former sheriff of Breckinridge County. He's charged with assault, operating under the influence, his second offense, criminal mischief, and leaving the scene of an accident. Today, the 51-year-old's in court to change his plea from not guilty to guilty, a decision he's already agreed to in writing. This will allow him to serve just 75 days in jail versus a possible sentence of up to 15 years if he went to trial and was found guilty of all charges. To make it official, all he has to do is say the words to Judge Janet Crocker.
At this time, is it your desire to change your plea from not guilty to guilty?
Do I have to answer that yes or no, or can I make somewhat of a statement that's
That is a yes or no answer, sir.
Will I have the opportunity to say anything further?
If it is your intention to change your plea from not guilty to guilty, certainly you'll have an opportunity to make any statement. But if it is not your intent to enter a guilty plea at this time, then I'm going to set your case for jury trial, and you're going to stop wasting my time and everybody else's time this afternoon.
Ma'am, I'm not trying to waste your time.
And then is it your intention to enter a guilty plea at this time or not, sir?
No.
Mr.
Why am I wasting your time,
Mr. Chambers.
ma'am?
The judge ignores the question and checks in with the prosecution.
Why am I wasting your time,
Mr. Chambers,
ma'am?
what is the Commonwealth's position at this time, sir?
Your Honor, we would move to revoke the defendant's bond at this time.
The judge orders a brief recess, perhaps hoping Pate's attorney can remind him he's already agreed to plead guilty. Back in court, The judge tries again.
Let's get back on the record and see if we can sort this out. At this point in time, what is Mr. Pate's decision with respect to his guilty pleas?
So I believe I'll just let him answer that question if it pleases the court.
All right. So, Mr. Pate?
Can I say a few things, or?
I need to understand what it is that we're
I would
doing
just
here
like for the
today,
court-
Mr. Pate.
Yes, I had every intention of coming in here today and entering a guilty plea. It's difficult for me to enter a guilty plea for a lot of reasons, and I don't want this court to think that I am trying to minimize any responsibility that I had in this situation that occurred.
The problem is Pate doesn't agree with the assault charge and believes the prosecutor only added it because of Pate's position as sheriff and because Pate rejected an earlier plea deal.
I feel like I'm being very much bullied into doing something that's not right. And I want this court to know that Todd Pate holds himself responsible for everything that he did. It's hard for me to lay down and plead to felony charges that don't apply.
By this point, the judge has heard enough.
Is it your intention today to enter this guilty plea?
And if I could address...
This is either a yes or no. Are you going to enter your plea or not?
I guess everybody thinks it's funny. Let me just plea and get it over with for everybody.
This is a classic plea colloquy, where a judge confirms that a defendant's guilty plea is made knowingly, intelligently, and voluntarily. Under Kentucky Rules of Criminal Procedure 8.08, the court shall not accept the plea without first determining that the plea is made voluntarily, with understanding of the nature of the charge. Former Sheriff Pate's reluctance to give a simple yes, and his insistence on making a statement, indicates a potential lack of voluntariness or a misunderstanding of the plea's consequences, particularly his belief that he's being bullied over the assault charge. This creates a dilemma for the judge. Accepting a guilty plea that isn't truly voluntary can be grounds for appeal later. His comments, "Let me just plea and get it over with for everybody," sound less like a voluntary admission of guilt and more like resignation, which can make the plea procedurally suspect.
Speak to Mr. Chambers' motion to revoke the bond.
I've already ruled. I've already ruled at this point in time.
Ma'am.
We're done at this point in time. He's going into jail today.
These cases remind us that justice is a complex and often unpredictable journey, even within the hallowed halls of a courtroom. In the case of Lizette Gonzalez, Judge Fred Schott of Seminole County, Florida, ultimately granted the motion for judgment of acquittal, effectively overturning the jury's guilty verdict on the DUI charge. News reports from March and April 2015 indicate Judge Schott was later transferred from the criminal to the civil division, but he stood by his decision, stating he felt Gonzalez was treated unfairly due to Officer Wagner's false sworn statement. For Jenny Mariah Kelly, the California Deputy Attorney General, the transcript confirms she pled no contest to disturbing the peace, paid a $1,000 fine, and was ordered to complete anger management classes, resolving the charges of resisting a peace officer and disturbing the peace. And finally, Todd Pate, the former Breckenridge County Sheriff, after his bond was revoked and he was sent to jail, eventually did plead guilty. Public records from July 2020 confirm he accepted a plea agreement for the DUI charge and 2 counts of wanton endangerment, serving 75 days in jail, with credit for 46 days served, a 12-month license suspension, and participation in a substance abuse program. He later ran for sheriff again in February 2026, stating his charges were dismissed as part of a program for low-level offenders.